Good morning, Ms. Juzak. I hope you can hear me well.
Yes, I can hear you. Hope it's the same on my side.
Yes, it's perfectly working. Thank you. So now we move to a key dimension of digital citizenship, namely how fundamental rights and EU values are protected in the era of artificial intelligence. And during this session, we will explore the UAIX risk-based approach, including prohibited practices, high-risk AI systems, and tools such as the fundamental rights impact assessment to ensure that innovation remains trustworthy, human-centric, and aligned with European values. So without further ado, Ms. Juzak, I leave you the floor.
Thank you so much, and thank you for the introduction. Perfect. So yes, let's start. First, a few introduction points. So now we are jumping from General Data Protection Regulation to the DA Act. The DA Act is the first world comprehensive law for the AI. In the EU, we have decided that we want to regulate the AI uptake to make sure that the use of AI in the European Union is safe and that we can trust AI, while of course having in mind innovative approaches and generally the development of AI. The regulation is, I think we can still say, brand new. It was adopted in 2024. And as it applies progressively, not all of the provisions are actually applicable already now. We do have an important milestone this summer with the 2nd of August 2026, where the enforcement powers of the AI office and also market surveillance authorities come into play. So we will be able to enforce specific rules of the AI Act, not all of them, because as I said, the AI Act applies progressively. Hence, for example, high-risk AI system has been famously postponed by the Digital Omnibus and AI that will be adopted officially in July to the next year. So for that, for example, enforcement kicks in already only next year. Maybe the last point here, I wanted also to mention that the AI Act is so it's a legal framework that is designed to be responsive to new developments, because the college legislatures were aware that the AI is it's a field that is ever changing. So the AI Act is designed and specific rules as easy to and quick to adapt, and also there's a frequent evaluation prescribed. For example, that applies to Annex 3 high-risk AI rules that I will be speaking a bit later in the context of fundamental rights, where the Commission is tasked to review all of the use cases under Annex 3 and to make sure that we are addressing all of the current risks that are presented. So diving into fundamental rights and how the AI Act addresses them. First and foremost, the AI Act, as we see already in the first recital that you see on the screen, directly addresses fundamental rights. We see that it has been designed to ensure a high level of protection of health, safety, and fundamental rights. We have to remember that the AI Act is a product safety regulation, so primarily it focuses on the product. So that's why we have also health and safety. But fundamental rights is an important part of that. And throughout the requirements and parts of the AI Act that I will present later, you'll see how it is enshrined in the AI Act. When we talk about the fundamental rights, of course, we also talk about data protection and private and family life. There are a few key concepts that I wanted to bring your attention to. So as I said, this is a classic product safety regulation, but some specific parts that relate to the processing of personal data for law enforcement purposes is based under Article 16 of the Treaty of the Functioning of the European Union, which establishes the right to the protection of personal data. So those very specific provisions have been based on Article 16. You can find specific references in recitals in the AI Act. Further to this link with the data protection world, the AI Act refers to the definition of personal data and special categories of personal data to for example, profiling that comes relevant within the Annex 3 high-risk AI system use cases. With that being said, the AI Act does not affect EU data protection law, meaning GDPR, Law Enforcement Directive, GDPR for the European institutions and bodies, except for a few provisions that establish legal basis to process specific personal data. So we do have a legal basis to process special categories of personal data for bias detection and mitigation under Article 10.5. Under a Omnibus, it has been extended to also cover not only high risk, but providers of non-high-risk AI systems and GPI models, because we recognize that the risk of discrimination resulting from bias is also present there. And we also have the second legal basis for further processing of personal data for public purposes within the scope of the AI regulatory sandbox. So there is this legal basis to ensure that the providers or prospective providers that bring the project to AI sandbox can further process previously collected personal data, and they have legal basis to do that. Data protection authorities are associated with AI regulatory sandboxes that are supervised by the market surveillance authorities if personal data is part of processing activities. So if the project brought by and selected by the member state that runs the AI regulatory sandbox includes processing of personal data, then automatically data protection authorities are associated. So they supervise, guide those companies through the compliance under EU data protection law. So as you see, there are those specific links to EU data protection law, but I think the main thing is that, yes, EU data protection law is not affected, except those two legal bases, in a sense that, for example, if there is a system that is classified as high risk under the AI Act, normally it does not impact any assessments under EU data protection law. So it can still be non-compliant with the EU data protection law, it can be compliant. It really depends on the actions of controllers and processors. However, for example, under AI Act, it is classified as high risk. So we have to remember that these are separate frameworks, but mutually reinforcing, so they do not contradict each other, but rather reinforce the objectives of both of them. The AI Act is technology neutral in a sense that we don't focus on specific technology because we want it to be on future-proof, even though we do have quite broad definition of AI system, for example, but we focus on specific use cases that produces risks to health, safety, and fundamental rights. As I will explain more thoroughly further, the AI Act follows risk-based approach. This means that we look at the risk and then we apply specific rules that are relevant for those risks. So here you can see a pyramid that tries to illustrate in a simplified way what is the AI Act's approach and how those risks are tiered. So first we have unacceptable risk, which is reflected in the prohibited AI practices. So it's when the AI systems pose unacceptable risk to fundamental rights and union values, and those are prohibited. Then we have high-risk AI systems that I already mentioned. So we recognize that they pose high risk to health, safety, again, and fundamental rights. And because of that, they are allowed to be placed on the market. But before that, you need to comply with a set of specific requirements to make sure that they are safe. Then, as a third layer, we have a specific transparency risk, and here we have specific AI systems that pose somewhat limited transparency risk, and then there are specific requirements that need to be complied with. So here we are talking about the deep fakes, chatbots, in some ways as well about their emotion recognition and biometric categorization systems, for example, to let the individual know that these are in use. Often those rules are to make sure that the human so that the individual in front of a laptop, for example, understands that that the interaction with the chatbot is not interaction with the human, but it's interaction with the machine, with AI. So then there are clear rules. For example, as well for deepfakes, that we understand that something has been generated by AI, and it's a deepfake, even though it looks very, very real. So very much in a nutshell. And then the last layer, we have minimal risk or no risk, where we have no rules except of a very general AI literacy obligation to basically understand the risk and how AI systems work. That, for example, is deployed in specific environment by the employer, etc. So here I'll focus further specifically on prohibited practices and high-risk AI systems, so the first two layers, because these have specific links to fundamental rights, as you'll see very quickly. So we have 8 prohibited AI practices. So the AI Act prohibits placing on the EU market, putting in the service, or just using certain AI that is manipulative, exploitative, that provides for social control or surveillance practices that with their inherent nature violate fundamental rights and other union values. So with union values, I speak about human dignity, freedom, equality, democracy. But again, here we as well have very important fundamental rights. So we talk about the right to non-discrimination, data protection, private and family life, the rights of the children, freedom of expression and information, freedom of assembly and association, and that's very relevant in the context of surveillance practices, freedom of thought, conscience and religion, effective remedy and fair trial, presumption of innocence and the right of defense, and so on. So we really have the overarching approach to make sure that those practices do not exist in the EU, and the European citizens are protected from them. So here you see the list of 8 prohibited AI practices that are currently in Article 5 of the AI Act. Some of them relate to the use of biometric data. So, for example, the real-time remote biometric identification for law enforcement purposes that was specifically designed to avoid mass surveillance by police, law enforcement. We have biometric categorization based on certain sensitive information, as, for example, race, political affiliation. We also have emotion recognition, so recognition of emotions and intentions, specifically in the workplace area that has been considered as particularly sensitive. We have scraping data from the internet that is untargeted. We have specific risk assessment risks that are also addressed. You see social scoring. and the first two ones are the ones that are perhaps sometimes already visible in the society around the world, of how the interaction with AI can manipulate and actually have devastating consequences on the human life, is it like physical or mental health. I also wanted to mention that we will have two additional prohibitions that relate to AI systems that generate or manipulate realistic material, depicting an identifiable person's intimate parts, or also sexually explicit activity without consent, as well as specific provision relating to CSAM, so child sexual abuse material. There are specific conditions that I won't go very much into detail, but these have been already agreed by the co-legislators, because as you probably know, the Digital Omnibus on AI has been already both adopted in the Council and the Parliament, and now it's undergoing the technical processing, and very soon it will be published in the official journal, what we expect still this month. The last point on the general overview is that I wanted to mention, that I think is mentioned here, is that the Commission published already more than 1 year ago the guidelines on prohibited AI practices that really go into very, very detail on each of 8 of those existing prohibited AI practices, with specific examples that illustrate what is prohibited and what is not prohibited, which are very useful for companies and any providers, any operators to comply with the AI Act, and obviously not put on the market any prohibited practices. Looking at the time, moving to high-risk AI system classification and classification guidelines. As you may already know as well, we have recently published draft guidelines on classification of the AI systems under Annex 1 and Annex 3. So to give you a general overview, the co-legislators recognized, again, that some systems can be allowed, but pose enhanced risk to safety, health, and fundamental rights, and therefore should be addressed and should be allowed if and only specific requirements are complied with. We have 2 places, let's say, that address high-risk systems in the AI Act. We do have Annex 1, that lists relevant product legislations. So you have machinery, toys, medical devices, etc. And we have Annex 3 that lists very specific 8 areas with specific sub use cases in each area that are identified. So we have specific biometric systems. We have critical infrastructure, we have employment, education, essential services, and we have, of course, law enforcement, border management, and as well the use of AI systems in justice and democratic processes such as elections. You may see that all of those areas somehow, perhaps the last 3 and the first one, are a bit more directly already hint the link to fundamental rights. In biometrics, it's also very specific, because here the 3 use cases that we have for biometrics, which is the remote biometric identification systems, emotion recognition systems, and biometric categorization systems based on specific sensitive attributes. All those 3 use cases, the common link is the fact that the biometric data is processed. Here it's quite detailed, but what's often pointed out is that the AI Act deviated from biometric data definition from the GDPR. So it has a different definition that is made on purpose because we want to cover emotion recognition and biometric categorization as well, while biometric data definition under GDPR is linked to unique identification of uniquely identifying of natural persons, while in the Act we don't have that, because for biometric categorization and emotion recognition systems, the identification is not key. So in categorization, it's assigning individuals to specific category without identifying them. And with emotion recognition, it can go both ways. So for example, with visual, so like with the face, when you have the biometric data, you can identify, but we have also other biometric data that not necessarily will uniquely identify the individual, and hence it's covered by the AI Act. But it has been made on purpose, and that's also what we try to clarify in many guidelines that we produce now in the AI office. What's something important for Annex 3 and the high-risk AI systems is that even though they might be classified as high risk, they if they don't perform profiling as defined under the GDPR, and they fall under four use cases of filter, what we say, that is established in Article 6 of the AI Act, then the providers won't need to comply with the specific requirements for high risk, because we find that even though they initially could be high risk, they perform either a narrow task, or it's just an improvement of the human activity. So it's really important that those systems wouldn't be treated as high risk per se, because in the end, the specific task they perform is actually not high risk. To really put it in a very simplified way, so that we make sure that those AI systems that don't impact or influence the decision making, for example, that is covered in Annex 3 very thoroughly, don't need to go through this very thorough procedure of compliance with high risk requirements. The high risk requirements, just to very briefly go through them, they relate to specific documentation, to specific transparency, information in the AI value chain between the providers and deployers. They relate to the data quality, they relate to the accuracy of the AI system. Stop here. That's just to make sure that I make also some comments about fundamental rights impact assessment. So as Julia mentioned, this is a tool that is required under Article 27 of the AI Act. It's to assess specific risk to fundamental rights. The AI office is currently working on a template, and as prescribed by the AI Act, it needs to adopt and publish a specific template. This the conducted FRIA needs to be communicated to the relevant market surveillance authorities that supervise and enforce the AI Act. The FRIA has some similarities to very well-known data protection impact assessment under the EU data protection law, but there are also very significant differences between those two tools. The main difference is that fundamental rights impact assessment covers more broadly any fundamental right that has been recognized as subject to within the specific AI system as risky, while data protection impact assessment primarily focuses on data protection rights. The similarity of those, like one example could be that, for example, that both FRIA and DPIA needs to be done prior specific activity. So DPR prior specific processing activity, and FRIA prior putting a product and offering it on the market. FRIA also prescribes that there needs to be specific measures identified in order to complete it, and needs to be also updated. One of the differences, it's also a different approach between DPIA and FRIA. With FRIA, the obligation lies with deployers of the AI systems, and it's somewhat limited in scope. So we have primarily Annex 3 use cases without critical infrastructure, but then there are also specific requirements as to conditions as to who has to do it. So it has to be a deployer. Either it's a body governed by public laws or public authorities, etc. Either private entities providing services specifically for public services. So it's quite a narrow scope when we think about it. So majority of entities that will be doing fundamental rights impact assessments, it's actually public authorities or service providers that are providing something specifically for public authorities. And with that, I am spot on the dot. So just I didn't want to prolong and influence other presentations. I'm happy to answer any questions.
Ms. Joseph, thank you very much. So I believe you just delivered a very insightful presentation, which went through the details of a technical regulation of the EU, which is also very new, as you underlined at the very beginning, and is still trying to keep the pace with the rapid evolution of the technologies and especially the AI evolution. So I'm seeing there is a message in the group chat. No, I thought it was a question. Instead, it's a person who needs to leave, but thank you very much for what you shared with us today. I don't know if anybody else wants to jump in, sharing doubts or asking for further clarifications. Because otherwise, even this time, I may start breaking the ice with a question for you. I don't see many raised hands so far. So, what I wanted to ask you, mine, while looking at the risk-based pyramid of the AI Act, and in particular, my question is about how this framework can, let's say, remain dynamic over time. What I mean by this is that I think we are all very much aware that we are living in a period where some of the core EU values, even very base of it, which is democracy, the rule of law, and non-discrimination, seem to be increasingly under pressure, or at least, let's say, politically reinterpreted to support different positions. And at the same time, as I just said, the AI technologies are evolving at a pace that is, let's say, much faster than traditional regulatory cycles. So I was wondering how, in this context, can we ensure that the risk assessment that underpins the AI Act can effectively remain up to date, relevant, even resilient, both to technological change and also to the potential shift in the way that fundamental rights and EU values are understood or challenged?
Yeah, sure. Happy to answer this. As you've seen firsthand, so we've already had few additions, so the 2 added prohibited AI practices to the list of prohibited AI practices, as co-legislators recognize this specific risks, in particular related to CSAM or non-consensual intimate images, also in the scope of the AI and AI-generated materials. The AI Act is future-proof in the sense that there are specific mechanisms recognized in the regulation that allow the Commission to review and update specific rules. So that relates to prohibitions, and that also relates to the high-risk AI systems. On prohibitions, each year there is a specific report produced by the Commission, which analyzes the specific state and current practices on the market, and allows the specific reflection of whether are we lacking something, do we need to address new novel risks. The same goes for high-risk AI systems in Annex 3, where the Commission can actually, there are specific conditions included in the Act, and the Commission can review the existing list and change it based on specific foregoing risks and whatever we see at the market as alarming for future. So the co-legislator did recognize that it's very difficult to foresee how AI will be developed in the future, especially when we think about decades. And therefore, there are those specific mechanisms that allow us to be allows the AI Act to be adapted and stay relevant within and for all of those changes.
Well, thank you, Dan. I think it's clarified a bit what the European Commission may foresee at least for the next future. As you said, imagine how AI will evolve in decades. It's really difficult for everybody, even for those who are daily working on its development. So I can only imagine for you working on the regulatory framework, and for us using it as citizens who are trying to raise their awareness about the benefits and the risks related to their usage. And I would just ask another question about that, like not really about that, but related to this point, because it was a curious point for me, the fact that you mentioned emotion recognition systems several times, and including also the restrictions introduced by the AI Act in sensitive contexts, such as the workplace and education. And what I was wondering is that emotions are deeply contextual, culturally influenced, and just often difficult to interpret even for humans. So how can regulators and organizations ensure that the assessments of the systems properly capture not only the technical risks, but also the broader impact on human dignity, non-discriminations, and even trust in institutions?
Yeah, so definitely emotion recognition systems are one of let's say the areas where co-legislators recognize, specifically, as you said, risks to fundamental rights, human dignity, especially in certain environments. So for the prohibited practices, we are talking about the workplaces, interpreted broadly, including, for example, recruitment. And in high risk, basically, we have all other emotion recognition systems. So if the system is not prohibited, it will always fall under a high risk classification. So that's one of the let's say safeguards that we always make sure that the regulators are aware, as well as the companies are aware that they need to comply with specific requirements and conditions to use those systems. It is a very complex materia, because as you said, in the Act, we talk about not only emotions, but intentions, because the co-legislators were concerned about circumvention of their existing rules by just saying, oh, this is not emotion and intention. So it's the co-legislators really tried to have the balanced approach to make sure that we really capture what is at risk, and that the citizens are protected. Obviously, when we talk about emotion recognition systems, we do have a definition in the AI Act, so that also leads citizens and also operators in the context what needs to be considered. We are talking about inferring emotions and recognition. And we are talking about biometric data processing. So without processing biometric data, we won't have emotion recognition system under the AI Act. So we are talking about inferring emotions from facial expressions, for example. What's surprising, I think, to some of the stakeholders, we are not only talking, because it's all of the emotion recognition systems, if under high risk, if not prohibited, we are not only talking about the very obvious situations when we have, for example, the body cams of police in the streets with the real time, where, for example, they might want to recognize aggression, infer aggression or specific situations, or where we talk about government surveilling society by inferring emotions in specific situations. But we also talk about some other, let's say, more private uses and, for example, entertainment uses. So we also talk about emotion recognition within video games, for example. And that also would be recognized as high risk, because the triggers for emotion recognition systems are only the fact that it's biometric data and emotional intentions are inferred. It's not the purpose. So it's not the purpose, law enforcement purpose, I don't know, playing a game and having a improved experience, because the AI system also analyzes your reactions to specific elements of the game.
Well, thank you. Even this answer gives a very broad, gives the complexity of the broader approach that you're required to adopt as regulators, and all the different contexts that you need to view and to assess while thinking about how to better regulate totally new dynamic compared to different even to the recent past. So I believe that today, with your presentation, you contributed even further to raise our awareness as digital citizens about what the AI Act can do to protect us, and also what we can do to be more attentive and more careful when approaching these tools. I don't know if from the public anybody wants to contribute further to the discussion, because otherwise, even in this occasion, I would thank Ms. Yuzak for the intervention of this morning. And of course, you would be more than welcome to attend the last part of the session, which will be delivered by Mr. De Brewer from EDRI. And we will take another short break now, and we can meet again at 12. Thank you, everybody.
Thank you so much.
Then we can start with the final session of today's webinar, which will focus on age verification and its implications for digital rights and data protection. This discussion will help us look beyond the technical dimension of age assurance and reflect on a broader strategic question, and namely, how can we protect minors online while safeguarding privacy, inclusion, freedom of expression, and fundamental rights in a digital environment. Mr. De Brewer, thank you for the presentation you will just deliver right now and for finding the time to explain us these topics this morning. The floor is yours.
Okay, thank you for the introduction. I'm happy to be here today. I'll start with a quick introduction of who I am, what EDRI is, and then I'll move on to the actual topic. So European Digital Rights, short EDRI, is a network of NGOs working in Brussels and in Europe on digital rights. We represent more than 50 members, which are distributed in the various member states, which are human rights defenders, technical experts, legal experts, a very big diversity of organizations. We're more than 25 years old, or nearly, and we have been working on mainly policy and advocacy, but we've done a lot of research, and we have been working on complaints and litigation to advocate for these same aims that we address through policy. We have a lot of work on platforms and platform safety, notably through the work on the DSA, the DMA, the GDPR, and the upcoming Digital Fairness Act. And our members and ourselves, we contribute to this whole dialogue about platform safety as well by looking into how platforms infringe the law, documenting that and submitting it to national authorities, the Commission, to the courts. Yes, I'll come to that. Now, the topic per se is age-verification today. Age-verification is a narrower set of techniques within the broader set of age assurance. You probably have heard of the big topic nowadays being, it's the big topic for me, but not for everyone. So it is a topic of controversy whether to protect people from online harms, and especially young people from social media harms, whether excluding them, excluding a set of people depending on their age through age verification might be a valuable method to ensure protection. And age verification has taken a lot of space in that debate, even though there are many different ways of protecting people online, which I'll get into. The scope of this discussion on age verification, however, goes beyond social media. It clearly goes beyond because there are policy proposals addressing age verification as a possible requirement on app stores, age verification as a prerequisite to access interpersonal communication apps like Signal and WhatsApp. There is already EU law on access to pornographic content. And yeah, so the current framework, I'll get into it now, but it already exists. It's not brand new. Age verification as a processing technique and as a gateway to services is nothing new. I'll start with a fun, palatable presentation of the acquis, like we say, the existing framework, and then I'll go into the age verification techniques per se. So, as a prerequisite, let me add also, I frame this whole discussion of age verification in the context of the agenda on protecting young people. Therefore, I'll also focus on the broader implications and the existing framework to protect young people, to show how age verification fits therein. So, as a first layer in a big, dense, tasty lasagna of law. By the way, lasagna is a Belgian thing to say. It's a saying in Belgium we use to say that it's the framework is already quite dense and intricate. So in this case, we have as first layer that the GDPR requires purpose limitation, data minimization, lawfulness, fairness of processing. This is super important to ensure that the data processing is not overbroad, it's not too intrusive, and it's fair, basically. And also, there's the requirement that personal data should not be made accessible broadly to an indefinite number of persons. This is useful in terms of protecting everyone, not just young people. One relevant provision specifically to young people is that the GDPR allows, as a legal basis for processing personal data, to use consent in some cases. But consent, the person consenting needs to be at least 16-year-old, and member state can lower that threshold to 13-year-old. That means that if you want to rely on consent as a legal basis for processing personal data, then you may need to check that the person consenting is of the right age. That is relevant for this debate. The second layer of the lasagna is that in the Audiovisual Media Service Directive, there's already requirements that some content should not be made accessible or exposed to minors. And the directive explicitly says that age verification is one of the possible methods to do this. It says there are other things to do, but age verification may be used there. Member states have not really used that yet much, but it's already in the EU law. Third layer, very well known, the Digital Services Act. Two key articles. One is quite broad. It says that providers of online platforms, or online platforms regardless of size, need to put appropriate and proportionate measures to ensure that a high level of privacy, safety, and security of minors is ensured. This is very broad, really not clear as to what exactly this means. And this is on purpose, because there are very different ways to achieve this goal of privacy, security, and safety of minors. One interesting addition in that very article, in the third paragraph, is that compliance with this obligation to ensure safety shall not oblige the processing of additional personal data in order to assess whether the recipient, the user, is a minor or not. So you need to provide the secure environment, you need to ensure safety, but that doesn't mean you need to check whether someone is a minor in order to give them that safety. Further article, only for the very large online platforms, the very big ones, they have to analyze, identify, and mitigate risks which stem from the services they offer, specifically the systemic risks that apply on a system-wide basis, not just individual. The DSA mentions here that among these measures, targeted measures such as age verification is something that can be considered. Again, it doesn't say that age verification must be considered. It says it's one of the measures that may be relevant, so consider it. The general spirit of the DSA is that platforms have to identify risks and address them so that the service is safe. This is different from the approach taken by, say, Australia, where the Australian government has decided to restrict access altogether from platforms, regardless of their level of safety. Here, the European approach so far had been to say, mitigate risk, and maybe, if needed, take targeted measures to ensure that, say, young people have the right measures, have the right environment. Next, there's the CSAR or chat control proposal, which, as I mentioned, has foreseen to have provisions on age verification being mandatory for app stores to check whether someone may or may not download any given app, and or for age verification on hosting providers and providers of communication services. This is still ongoing. This is not it's only a proposal being negotiated. It's not a law. And then there's the upcoming Digital Fairness Act, which aims to address this design of the architecture, maybe even business model if we can be ambitious enough. So manipulative design, unfair personalization, the burden of proof, the addictive defaults, the dark patterns, some of the things which are addressed by the DSA, not as explicitly, might be put into law here. Relevant because it makes online services safe for all consumers, and also because maybe the Commission will decide to restrict some provisions to minors only, let's say. But all this is taking place in a wider context, the discussion of protecting young people. Because we have these laws. They are being slowly enforced or not enforced, I'll get to that. But since Trump came in power, there have been clear budget cuts in safety and moderation services at the big tech platforms. Since the new legislature, since 2 years now, the deregulation agenda, so the omnibus that has impact on the e-privacy directive, the AI Act, and the GDPR, has been a process of weakening existing EU law that protect everyone horizontally. So we are seeing calls for simplification, including of the human rights protection, at the same time as we are hearing the same people often call for additional protection, but only for children, which is rather strange, rather inconsistent, I would say. At the same time, still Trump, the US is actively undermining the enforcement of our EU digital laws with the threat of tariffs, with an enforcement dialogue on the enforcement of EU laws on big tech platforms. And yeah, meddling every time there's a commission decision or an authority making decisions on fines and measures that tech platforms have to take. Furthermore, there's also the weak enforcement of the digital laws notably because of the Irish bottleneck in terms of Ireland is the country where most of the tech companies are based because of tax reasons, and therefore Ireland derives a lot of revenue from taxes. It's small taxes, but because of how many companies are based there, it's a lot of money. And therefore, there have been a lot of allegations and observation about how Ireland and Irish authorities may lack the right incentives to apply EU law, with the impact that, well, the laws that supposedly protect us throughout Europe are not really well enforced, thereby creating further harms, which then lead to calls for extra protection for children. Yes, the Digital Omnibus, for context, has a few interesting provisions which weaken protection in favor of algorithms and AI specifically. I won't go into there too much, but just to say that this is the context. We are weakening protections at the same time as we're hearing calls for additional protection for children only. I hope everyone can follow, and if you have a question, you can already raise your hand and I'll try to address it. Now, age verification per se. So the core of our topic today is this. There are different ways of doing age verification. I said, within a broader set of age assurance. Assuring that people have the right age can be done through different ways. You know how, well, you can declare your age, and you can say whatever you want. It's not changed, but it allows you to get a tailored service or to get a rejection because you're not of the right age. Of course, this is easy to circumvent because you can declare false age, but if you have the incentive to provide the right age because you know you'll get protection instead of exclusion, then this can work. The alternatives in terms of age assurance are tracking. So companies tracking your activity to then assess whether you might be someone of age 15 or 16 or 20 or whatever, which is quite intrusive. So that's quite clear that in the EU, we won't do that method. There's the use of biometrics, so scanning faces to assess whether you look like someone who's of the right age. Again, super intrusive, allows for, well, surveillance because you require showing your face in order to access a service. Just as problematic as uploading your whole ID document with or without your face to prove that you are of the right age. Again, this has the risk of, clear risk of surveillance because you don't know whether the data that you provide is actually deleted afterwards. It could be reused, it could be hacked. There have been many cases of this. Another method, which is less present in the debate right now, is age signals. So, for example, the provider Murena in France and Apple now have this service whereby when you set up the phone for the first time, you get a prompt saying, okay, what age group does the intended user of this phone belong to? Is it very young, less young, adult? And based on that, based on what the parent who bought the phone for their child selects, the phone then tailors the experience for the child, saying, well, the parent has some control and can decide whether they want to be involved in every time there's an app download or something like this, or whether it just wants to follow the app store's recommendation on age. But basically, this is a way to not verify age, but rely on the parent or guardian who buys and provides the phone to a young person to say, okay, this is the right age signal. Now it's on the phone's responsibility to follow through. This is interesting because it doesn't rely on actually providing IDs. It doesn't rely on providing other data than just the age bracket. So it's a declaration, but not by the user of the phone, by the person who provides the phone to the user, typically the parent of a child. But now, age verification in the EU, the Commission has been pushing something called, something they pitch as privacy-preserving age verification. This is based on the eIDAS regulation. The eIDAS regulation foresees the provision, the development and the provision to every EU citizen of a wallet, a digital wallet, which contains your digital identity credentials and which you are supposed to be able to use to log in with public administration online, for example, to access public services. You are always, the regulation says, allowed to use other means. You don't have to rely on this tool. And this regulation, the eIDAS regulation, has quite strong safeguards on how to ensure that the use of this wallet doesn't lead to surveillance. The Commission has decided to build upon this architecture for the age verification solutions it foresees. So the Commission recommends that age verification apps developed at national level, or if it is the case at EU level later, have the same protection, the same safeguards. Therefore, it provided a blueprint for an app which it showcased as enabling age verification that is privacy preserving. However, we hear about features that, so this app that the Commission has a demo for and which member states, some of them are copying, but not all of them. How is it privacy preserving? This is relevant because this talk is about the implications of age verification for data protection and digital rights. So we look first at data protection, then I'll zoom out and look at digital rights more broadly. Here in this case, data protection is ensured because instead of showing your whole ID, you are able to selectively disclose only part of the data, say only your age. Even though you have a whole ID, you can basically select a part of it and say only this data will go through and will be used. Moreover, it's not the data itself, your actual age, it will be a token that will be sent. That is, in response to a question, is the user more or under, is the user above 18 years old? You will be able to send a token that says yes or no, but not the exact age, which is quite nice. And further, since it's a token, since you only selectively disclose part of the data and they're not, the service you're trying to access is not able to check exactly who this is beyond having the data on the age, yes or no. This is called unlinkability. And altogether, there's the technique called zero knowledge proof, which bundles all this together and is a process whereby you get to prove to someone that you satisfy a given condition. It can be age, it can be something else. Without giving additional knowledge. In theory, this sounds great. In practice, there are practical issues. First, because the eID wallet is still being developed, none really exist that match the regulation. Notably because zero knowledge proofs, they don't exist on the market yet. What the wallets currently do and what the age verification apps currently do, they issue age verification certificates in batches. That is, they, instead of doing this very secure process that they should do, they're issuing multiple certificates, shuffling them, and then distributing them to the users. This has implications on the ability to use this age verification method without being surveilled, because concretely, this leads to the possibility for the service to observe the user behavior. Notably, in the case of collusion, so if the service provider, which is called the relying party here, so the service you're trying to access and which asks for your minimum age, and the government which issues the proof of age to your wallet, if they collude, if they collaborate, they can still put 2 and 2 together and see who this user is and where they go, basically. This is very problematic because we're told that this is a privacy-preserving age verification method, but it's only privacy-preserving towards the service you're trying to access and somewhat towards the government, which gives the identity. It is not privacy preserving against surveillance, let's say, of law enforcement. If law enforcement wants to force a service provider to provide them the age certificates that any given user used, they can then use the government data to put 2 and 2 together and say, okay, now we can follow you, your whole activity. There are other issues with this, notably the fact that, well, there will be 27 different eID wallets. If there are age verification apps, there may be up to 27 age verification apps. That is a lot of entry points for vulnerability, for hacking, for leaks. If any of these is problematic, then it can weaken the whole ecosystem. But it also means that if we want to audit the code, the source code of these apps to ascertain for sure that they are not surveilling us, they are not enabling surveillance, well, that's a lot of work. And that's assuming that if the whole source code will be public. In the existing cases, for example, in Denmark, which has published a bullet recently, the source code is not fully accessible to researchers. So you cannot ascertain that it's all doing what it's pitched to do. Further, even this EU app demo is using biometrics because you need to scan your passport or your ID and then to compare with your face. And therefore, you not only need the camera and scan of your face, you also need a chip. You need a smartphone which has a chip to process NFC data. NFC is. I'll get to that. So, in terms of age verification methods, this privacy-preserving age verification is comparatively better than the tracking and the biometrics-based alternatives. That's clear. We don't want those that really enable very easily the surveillance in mass. However, this privacy-preserving age verification tool is not perfect, is not done yet, it's not ready, it's not on the market. So there are, as I discussed, some issues in there. Plus, for us at EDRI, the basic issue is not that they're not privacy preserving. Of course, if we use age verification, they need to be privacy preserving. However, the question I want you to ask yourself is, do we actually need age verification? Because as I discussed a bit earlier, the DSA, the spirit of the DSA is to mitigate risk, to identify risk and mitigate it. So the EU approach until now had been that services should tailor and reduce the harm. If a service reduces the harms well enough, in theory, there's no need to age verify the users. Plus, in any case, as I mentioned, the age signals, there are ways of ascertaining that the user is a young person without having to check the age of everyone, because age verification requires verification. You require tools to verify, you require ID documents or EID documents, and you require this whole architecture of control to gate services, whereas you could do it without that. You could have this age flagging thing where the parent says, okay, this is a device for a child, and the rest follows through. Let me see what I said else. In the Commission guidelines on the DSA, the Commission interprets proportionality as merely accuracy, reliability, robustness, non-intrusiveness, and non-discrimination. So these are the concerns that it puts forward for age verification to be considered proportionate. However, elsewhere in the guideline, it also says that proportionality is also about whether someone is not unduly restricted from expressing themselves, exercising their fundamental rights, for example. And this is for us the key concern with age verification. You may have privacy-preserving age verification, but to us, it remains a tool of censorship, a tool to gate people away from certain services. And that is not proportionate. If you have more proportionate alternatives, like mitigating risk, this has to be pushed through first. And this is what's happening. The Commission is examining, for example, TikTok on the basis of the DSA to see whether it is mitigating risks well enough. And preliminary conclusions are that no, that's not the case. But in parallel to trying to force services to be safe, they're also doing this weird thing of pushing age verification, whereas one comes from before the other, normally. Furthermore, so I told you I work for an NGO called European Digital Rights. We care a lot about privacy, we care a lot about surveillance, but we also care about other fundamental rights that are digital. Here, the key digital rights are freedom of expression, freedom of information, freedom of assembly. There are wider concerns about discrimination and the compartmentalizing of the internet, putting different internets, different spaces which cannot be accessed to certain people by certain people. Because in this case here, what we're talking about is a tool which, as said, verifies that you have the right age and then excludes you. What you are excluded from is important. In this case, social media. Social media is a very important tool nowadays to exercise your fundamental rights, whether we like it or not. The platforms are quite bad. We agree on that, and we are working to address that and to complain and to litigate against the platforms themselves as EDRI. But also, not all social media are as bad. There's like Mastodon, for example, which doesn't have any of the problems so far. Plus, nowadays, as I said, platforms are the way through which you can exercise your freedom of expression, information, and assembly. It enables people to exercise these rights at a scale that was not possible before. And therefore, if you exclude people, young people or adults, from these spaces, you heavily restrict their ability to exercise their rights. Why I say also adults? Because, as I said, to know who's a child, you need to know who's not a child. Therefore, everyone has to be checked. However, not everyone has a smartphone. Some people, like my grandparents, choose not to have a smartphone because it's too cumbersome for them. It's too complicated. They have an old phone, Nokia. They still access social media through the internet on the laptop. But if you don't have a smartphone with the existing EU app, you won't be able to age verify yourself. If you don't have the means to have a smartphone, same thing. If it's not recent enough to run the app, same. If it doesn't have the NFC chip, same. You cannot use your equipment to age verify yourself. Moreover, there's a whole category of the population who does not have the right category of documents, who doesn't have ID documents. I'm thinking of stateless people and undocumented migrants, for example, who do use social media for day-to-day important cases, and which will suffer from exclusion. And there's also all the people who lack the digital literacy. Let me see if I have, yes, I have a nice image. So depending on where you fall into this, in multiple or one of these categories, you are at risk of exclusion and of being unable to exercise your fundamental rights in the digital world meaningfully. That's quite important in terms of non-discrimination. Let me go through the rest. Privacy preserving here for the Commission seems to be preventing unnecessary data collection, unauthorized access, or misuse. It doesn't mean that surveillance is completely prevented, and it does not mean that anonymity is preserved. Let me see, Julia, in terms of time, how much time do I have until the Q&A? I understand it's quite soon, the closing time for the presentation.
I believe that if you still want to take 5-10 minutes, it's fine.
Okay, thank you. Let me go quickly through the slides to see how much there is. Okay. Rather quickly, so I've been focusing on social media, but of course there's other applications of age verification, as I said. But online spaces have clear benefits. There are drawbacks, there are harms, but there are clear benefits, as highlighted by many organizations and many international organizations as well. And therefore, what we at EDRI advocate for is to addressing the root cause of the harm instead of excluding people, and enabling young people to become autonomous and resilient. Because not every harm can be mitigated, but most of the harm can be mitigated one clear analogy is that social media is not like, we don't age gate social media like we require an ID for alcohol or for tobacco. It's not the same. You don't exercise your rights by buying and using tobacco. Whereas the better analogy would be cycling. Through cycling, you're able to reach more people than you are on foot. But cycling is not safe, especially in town. It's deadly. Yet we don't ban children and young people from cycling in the streets. What we do is we act at the collective level and at the individual level, and you need to do both. At the collective level, we adapt the roads, we put bicycle lanes, and we adapt the law. And at the individual level, we equip them. We give the little wheel, the jacket, the helmet. We teach them. We go with them to school until they are able to do it themselves. And this is a better analogy than an ID check, because here, for social media, this is what we need to do. We need to address the collective level, addressing the harm, ensuring that the harm doesn't occur for young cyclists and adult cyclists. And equipment level, we need to equip people with the skills to navigate streets safely when the streets are safer. Because anyway, if we don't do this, the age gates we put in place will be circumvented. This is very clear in Australia with the age gates. There's up to 80% or 70%, depending on the reporting, of young people who still access online spaces, not just because it's easy to circumvent, but because they want to circumvent. Maybe they want it even more because it's forbidden. This is a forbidden fruit effect. It's even more interesting once it's forbidden. The thing is, even in the EU, it will be able to any age gate we put will be circumventable, because VPNs are a thing. Tor, the browser, is something that you cannot ban. We can only protect and use. But even the EU app with its privacy preserving features will not be able to prevent, say, an older relative or an older friend to age verify themselves through their own privacy preserving age app for someone else. I could age verify myself on the account of my younger brother. Since it's privacy preserving, there is no way to know for the service or for the government that this is not the right person who is age verifying. So circumvention will be a thing. So if we don't do this right, first, we miss out on a huge opportunity to address the harms for everyone structurally, and we only push children in the darker corners where they will pretend to be adults by circumventing the age gates, and therefore be exposed to whatever practice we consider adults mature enough to be exposed to. So yeah, more data on circumvention, on parents themselves helping in China and in the US notably. The UK minister asking people not to use VPNs after the Online Safety Act came into force. And then quickly, we need as a solution to acknowledge the harms, to acknowledge the urgency, but to take an approach which does not exclude. We need to empower people. We need to protect people. That comes through the enforcement of existing laws, which I mentioned is problematic because of Ireland, because of the Trump pressure on the Commission, etc. We need additional laws like the Digital Fairness Act, which, in addition to enforce GDPR and DSA, will bring additional safety. And we need a whole lot of additional measures which are not digital per se, like giving and teaching digital literacy. I will stop here and I can come back to them if needed, but I'll stop here. If there are questions, I can come back to them, but otherwise, happy to have specific questions. I wonder among the participants whether there are some who have experience with age gates, age verification methods. I don't know whether you're all based in Brussels or in different countries. I don't know what your experience is. Let me know.
If anybody wants to jump on this question and perhaps share their own experience, because there are also some people connected not just from Brussels but also from other European countries. It would be very interesting to understand what different landscapes and difficulties that they experience in their own countries they have. Otherwise, once again, you made me curious about a couple of aspects that you mentioned during your presentation. So, in particular, you highlighted that age verification is often presented as a way to protect minors online, but that on the other hand, it can also raise significant concerns around privacy, data protection, exclusion, also freedom of expression, of course. And in particular, you mentioned the future role of the EID wallets and the fact that having 27 different versions could create indeed vulnerabilities or the least inconsistencies in the implementation phase. So, what I would like to ask you is whether, in your view, and how, in your view, can policymakers ensure that age verification measures, including the ones that would be based on EID wallets, remain truly proportionate and secure and privacy preserving without creating further new barriers to digital participations, nor undermining the very rights that they are meant to protect?
Thanks for the question. Well, the best way to ensure that they are proportionate is to only use them where proportionate. That is, we should not use them as a widespread measure, but only where it makes sense. That is, only after other methods have failed, because if you manage to mitigate risk, you don't need to age verify people. But also, the current focus on privacy preserving is obscuring the very use. So the debate is focusing on how we can make age verification methods better, rather than asking where we should use age verification at all. So yeah, does that answer your question?
Yes, thank you. Actually, then, building on this point, if age verification tools, so including the EID wallets, can only be one part of the solution and may still carry risk of exclusion, vulnerabilities, or maybe even uneven implementation, then what should policymakers prioritize alongside them? So, should the focus be more on stronger enforcement of existing rules, safer platform design, digital literacy, or support for families, schools, young people? So, how can we make sure that minors are protected online without simply shifting the burden onto users or limiting their ability to participate as active digital citizens?
Thank you. I think as EDRI, we are very critical of the slow pace of the DSA enforcement. The Commission is very timid, and digital service coordinators, the national authorities, are also doing nothing so far. This is very important because since the rules are not really being used and enforced on the platforms which abuse the situation, this gives an impression to people that the rules either don't matter or don't suffice. It basically creates the very issues we're trying to tackle. The DSA itself, if well enforced, has the potential to address most of the problems. A very simple case, for example, one of our members, Bits of Freedom, with our help, documented an issue with Meta, how on Instagram and on Facebook, Meta was infringing the DSA, a very clear infringement. And our member did two things. One, they submitted a complaint with the Digital Service Coordinator, the Irish authority. And second, they went to court directly to take the matters in their own hand, because they know that the national authority will be slow. What happened is that the court assessed the case, judged that Meta was indeed infringing the DSA. So we won. Then Meta appealed. It's normal. It's a normal process. But we won the appeal again. And by that time, it's been more than 1 year. The national authority, the Irish, has finally done one thing. They started looking into the case 1 year later. Whereas here, a court has looked into the case, judged, looked into the appeal, judged again. So this to show that the situation is not tenable. If we want to protect people, we have useful laws. We may make them better. We may need additional, like the Digital Fairness Act. But if we don't enforce the ones we have, it makes zero sense to keep pushing for additional protection. Another case, for example, is Ireland again. It has badly implemented the directive which enables class actions. And one of our Irish members has sued the government because they wanted to do a class action against big tech platforms to protect young people. So in the name of young users who are indeed harmed by the platforms, they wanted to take the case to the court. But the Irish implementation of the law is bad and doesn't allow for it. And therefore, again, we are stuck. So yes, indeed, lots of enforcement is needed, much more than we see now. But as I said, other measures are needed. We cannot expect people to basically turn, let's say, 16 years in a day and to be mature magically without having been able to exercise their autonomy and resilience on online spaces. If we don't address the harms and say people under 16 years old cannot access online spaces, what happens is that people, as soon as they turn the right age, they are pushed into this toxic pool where they are supposed to be mature enough, but obviously won't be. So we need to address the harm, and we need to teach young people, parents, educators on how to navigate the remaining harms. Let me see if I have something else to mention here.
Well, I think in any case, you just touched upon maybe the most important topic, which is awareness, both from those who are already in a more adult phase of their life. As you said before, we can only know who the minors are if we know who the minors are not. So it's fundamental that those who already have the tools and the instruments to go understand the digital environment they're working on and what risks it may entail for minors can effectively use the digital instruments to avoid as much as possible that any risk is produced towards those underage. I don't know if anybody else wants to perhaps add a comments or share a thought in this regard.
John Baptiste.
Yes.
Please.
Thank you very much, Mr. Simeon, for the very good presentation. I think we all share, the idea that a holistic approach is necessary in these cases because really it's a very complex. Child protection is a very complex thing. I thank you for having highlighted very clearly, the legal aspects, but also for having emphasized the role of education. I think that was exactly what Julia was trying to say. Julia, you asked the question that was, that I would have asked. What is the role of education, of adult education in all this? In the sense that institutions, especially education institutions, schools, the staff, but parents as well, because even the adults are having to adapt to to this new reality, and they're at a loss. They really don't know how to handle it. Many parents don't know how to handle it. I live in Italy, and we work a lot about educational poverty. These are kids who have problems with their learning experience because they come from poor backgrounds. Okay, they don't have the support. Yeah, so it's not only material and economic, but also in terms of parental competencies. So my question is, what is being done to invest adequately in the process to accompany these young people? Because we can't go back anymore. We know that the rights of children, of our children today, come directly from the CRC, which emphasizes their participation, okay, as part of the learning process. So they need to participate. And as your previous colleague was putting it, finding a balance between an interpretation that is too broad and one that is too restrictive. Yeah, in both cases it won't work. So it is a societal thing. So I think here it's important also to bring in the adults and the role of adults, yeah, in creating that environment that can protect and guarantee the rights of the young ones. So this is just what I wanted to share from this point of view. Just a small thing. I work on human rights education, and I visit a lot of schools, primaries and secondary schools, young people. And what I have seen, what happens, okay, the best we get in schools is asking the pupils or the students to hand in their iPhones or their smartphones when they enter the class, and it's given back to them when they're getting out, which is good enough, okay, because then they can concentrate on the work that they have to do in class. But there is very little about how educating them, and I think the teachers themselves don't have the competencies, to help them to use social media, or also we talked about artificial intelligence to their advantage, and being careful, being able to protect themselves, knowing the limits within which they can work. Then this way, I think also the whole legal aspect will come in. I would also add the issue of sanctions, because having laws that don't foresee the sanctions and so on normally create problems. Anyway, thank you very much for your experience, and I think experiences like that of the organization could be also, and these are best practices and models that can also help to improve the policy making itself. Yeah. So thank you very much.
Thank you. I really like how you brought in the socioeconomic aspect, because in your first remark, because indeed people who have fewer resources, especially parents, don't have the time and energy nowadays with their multiple jobs, and with the current state of affairs, to also take the time and spend time with their child online and offline, to accompany them, to help them grow autonomous and resilient. And therefore, these people who buy facility because they don't have an easy way of doing it, they don't have the time, just give a phone to their kid so that their child can entertain themselves and not bother them. These same people will still face the same situation once age verification will be in place. They will just age verify themselves on the phone and give the phone to the child, so that the child does not bother them and they can go on with their life. But indeed, these people also may not have the tools, the education, the knowledge about digital literacy. However, this issue, before we go into digital literacy, it's really important to address the systemic structural issues, because we cannot ask every individual to go through every setting of every app on their phone to ensure that it's privacy preserving, that it's safe, that people don't message you who are strangers, etc. These should be by default. And as per the GDPR and DSA, they should already be by default and enforced to be so. If we don't enforce that, digital literacy is doomed to fail, because we cannot require of individuals to fight systemic structural issues. But indeed, once we have that, and in parallel to the fight for enforcement and safety online for everyone, not just for young people, we also need the literacy, and we need the tools. We need to empower people. Therefore, the collective and individual approach. I mentioned that protection needs to be for all, because if we don't protect everyone from these toxic and harmful features, well, parents will be hooked just like they are now, and they will still show the example to their child of what it means to be, mature, old, empowered. Well, just be on your phone and stuck to it. If young people look at their parents and see just someone on their phone, they will copycat that behavior. So it's also why we need to address it for everyone. In terms of phones in schools, we don't have, as EDRI, a position on this. I personally think that it's useful to ask such a policy, no phones in schools. However, with caveats. One is that sometimes in some classes nowadays, teachers use digital media and phones to educate. So if they manage to do that, it's on them, great. And they should be empowered to do so, where it works. Also, if we just take the phones away without the young person understanding why we do this, the day they become a bit more autonomous, say they go to university, they will still be stuck to their phone in class. No one will be there to tell them, hey, you're not paying attention, you might miss out on information, and you might miss some important things, and you might fail your exams. And well, no, we have to not push them, but take them by the hand and enable them to learn, to become autonomous. If we force something onto them without explaining in them, without them understanding what the value of that is, it's doomed to be a short-term effect instead of long-term benefits. That's what I can say within my frame.
Thank you very much.
Well, thank you very much also to Mr. Namak for the interesting question, also for sharing your personal and professional experience in regard of the topics that we touched upon today. I hear that our time has run out, but I invite you all to share potential questions or doubts, both here in the Zoom chat and also by email. You will see the contact at in the registration reminder that you received even this morning, and in the email that I will send you afterwards at the end of the event today. And what I just would like to do right now would be to thank very much all our speakers and all participants for joining us today. We believe that this webinar has offered a rich and very timely overview of what digital rights and data protection mean in practice for European citizens, organizations, and institutions. We started the presentation today with the focus on the Digital Omnibus and the simplification of the EU digital framework, which helped us understand how the European Union is working to make the digital regulation clearer, more coherent, and even maybe more importantly, more effective, while also preserving a high level of protection for individuals and personal data. Then moving to the role of fundamental rights and EU values in the era of artificial intelligence, we explore, thanks to Ms. Juzak, the AIX risk-based approach and prohibited practices, as well as the high-risk AI systems, and the importance of tools such as the fundamental rights impact assessment. And these was useful to remind us that innovation is not only about what technology can do, but also about what kind of society we want technology to serve. And finally, now with Mr. Brewer, the Brewer, we focus on age verification and its implications for digital rights and data protection. So addressing a highly relevant and sensitive debate, namely how to protect minors online, while also safeguarding privacy, inclusion, freedom of expression, and broader fundamental rights. So there was a common thread behind these three different interventions, and it clearly emerged across all of them. That is, digital transformation needs rules, but it also needs awareness, trust, responsibility, and strong enforcement. In other words, digital citizenship cannot be considered just a checkbox exercise. It is rather an ongoing strategic capability for Europe's future. And on behalf of the Italian Chamber of Commerce in Belgium, I would like to sincerely thank Ms. Beizitere, Ms. Juzak, Mr. De Brewer for the valuable contributions they provided this morning. And I would also like to thank DLearn for the collaboration within the BUILD2026 project. Final note, this is not the end of this, let's say, journey. The webinar series on digital rights will continue, and we have already scheduled a second appointment on the 29th of October, when we will focus on media literacy, which is another key pillar for building more informed, resilient, and empowered digital citizens.